Good morning. It's Tracy Prachu here with the RCAW, and I am so excited to have Trent Cotney from Cotney Attorneys and Consultants with us today, talking about critical contract provisions. And this is our first Lunch and Learn of the fall series. And I hope you all had a great summer, and we're looking forward to hearing from Trent. So I'm going to turn this over to him right away and let him get started.
Great. Thank you so much, Tracy. And, kudos to you guys, Roofing Contractor Association of Washington and Tracy. You guys have really done a great job navigating sort of COVID-19. I love all the newsletters. I love the information. So round of applause to you guys. You do great. So we got a lot to cover today. Contracts is something that I live and breathe, throughout our firm and, in all of our offices. We probably do hundreds of contract reviews a month for roofing contractors. If we're not reviewing contracts, then we're litigating provisions in contracts. And what I want to do today is I want to really touch on what I think is absolutely the most important stuff. Now, for those of you that attended my last webinar that I did, I talked about navigating volatility issues with materials. There's been a lot that's changed since I've talked. So guess what you're going to get? You're going to get the brand new contract provisions. And I got to tell you, nobody else has got that. Okay, not even NRCA at this point. So this is going to be fresh for you guys. You get it first. Okay, we're going to talk about key construction contract provisions in general, and then I'm going to give you some key roofing contract provisions. Now, keep in mind, I could talk about contracts for 2 months, but I got 1 hour, so I got to condense it as much as I can. And feel free to ask questions throughout. I monitor the questions, so I'm happy to answer whatever you got. So with regard to the materials issue, there are a variety of contract provisions you need to make sure that you've got in your contract or that you're editing if you receive them from owners or general contractors. The first is the revised force majeure provision. Okay, force majeure is an act of God. It basically means that something has happened that has made it impossible for you to perform under the terms of the contract. We all became aware of what this provision was during COVID-19. But what I've done is add material or equipment unavailability. Okay, that gives you a potential argument to make that in the event that you can't get a particular system or a particular material, that you might be able to claim act of God, therefore making your inability to move forward permissible. It could also potentially give you the opportunity to make a claim. So this is a provision that you definitely want that in there. I'm assuming as I roll through these, and I'm not going to sit here and read every single provision, you're probably going to ask, can I get a copy of this? And the answer is, yeah, of course. I'm assuming Tracy's recording it, but if not, I can give you a copy of the PowerPoint. Let's talk a little bit about pricing. The pricing continues to be an issue. I just saw the recent August updates, more price increases across the board, anywhere from 5% to 35%. So they just keep increasing. So what happens if you get a price quote change in the middle of a contract after you've already signed it? Well, there's a variety of things that you need from a contractual standpoint to protect yourself. Obviously, there are things like force majeure that we just talked about. There are traditional change order process. But look, if I'm an owner or I'm a general contractor and I have a fixed price contract with you, you're not giving me any additional consideration to get a price increase. So why should I give it to you, right? So you've got to be able to come up with good arguments and justifications why you're entitled to do that. A lot of that is based on the fact that these are unprecedented times. It's unforeseen, unforeseeable, all those key terms. Okay, stuff I talked about at the previous webinar. What we want to focus on here is we want to focus on those key contract provisions that you need to have moving forward. So we'll talk about price acceleration. One of the things that I always mention is regardless of whether you're doing residential work or commercial work, I want to make sure that you are carving out as much as you can to make it cost plus as to certain materials. So with commercial work, I always like to say in there, to the extent that there are unidentified penetrations that need flashing, it is X amount, plus labor, plus burden, whatever it might be. Okay. So you're carving it out from the fixed price. You're allowing an adjustment based on what the current costs are. For an example, for residential is replacement of decking, right? We will replace, decking at the cost of blank, per plywood sheet or whatever the going rate is for plywood. Be careful with that because prices have been all over the place. plus labor rate, plus burden, however you want to do it. What I'm trying to do is give you carve outs that will allow you to get some of your costs back in the event, even if you have a fixed price contract. Okay. One of the other things that I've been working with contractors on is getting very creative when it comes to materials. One of the best things that I've done recently is I've convinced both general contractors and owners that they want labor only contracts and that they're in charge of ordering materials because they save on the markup. Okay, normally I would never do that, but this is great for the roofing contractor because guess what? That whole burden shifts to the general contractor or the owner at that point. You're doing DPOs, direct purchase orders. You're doing, having the general contractor bear the burden of whatever the issue is with relation to, getting the materials there on time. The other option is order the materials in advance and figure out ways to store them on site, off site, split storage costs, whatever it might be. Materials are not available. We all know that, right? It's going to be this way for a very long time. Dig your trench. Okay, it is not going to change anytime soon. We're going to be talking about this for a very long time. If you haven't seen it, NRC is doing a roundtable of manufacturers. I'm going to be on that next week talking about it. Recognize that this will probably go through the end of 2022 at this point. So you want to make sure that you're prepared in advance, get those materials as soon as the order as soon as the contract is signed. Now, one of the things that you're going to have to navigate are claims provisions. This provision here is a standard claims provision that I put in my subcontracts. So this is from the standpoint of a roofing contractor giving it to its sub. Okay, but more than likely you have a similar one if you're got it from a GC, right? And what it says is it says that you've got to give them notice of any particular claim within 5 calendar days of the event occurring. Okay, those dates, anytime you see a day or a notice provision, it is absolutely imperative that you watch out for that. Okay, because what I want you to do is I want you to paper the file. Okay, you've got to paper the file. The party with the best paper wins the day. Okay, so you need to make sure that you are doing everything you can to follow the guidelines at a minimum, because if you don't do that, rarely do you get to go to the next stage. Okay. When you are submitting claims for increased costs for materials or delays, again, you want to put your best foot forward. You want to have that industry backup, whether it's from manufacturers, from your association, whatever it might be, that supports the fact that this is a crisis that the roofing industry hasn't seen. In fact, I would say other than asbestos, it's probably the biggest roofing crisis that we've ever faced. Okay. So watch out for claims provisions because the devil is in the details. Highlight those days, right? The second day that I want to highlight for you is about 3/4 of the way down. It says such claims shall be received by the contractor not less than 2 business days prior to the time by which the contractor's claims must be made. Okay, so a lot of your provisions, if you're doing commercial work, they will say, yeah, we will submit whatever claim you want, brother. You give us whatever you want. But here's the catch. Okay, you're only going to get paid what we get paid for. Okay, and you got to get it to us in advance so that we can get it upstream. Okay, so that makes it really tough on me. I love to negotiate around that stuff to the extent that I can, but to the extent that you can't and you got to live with it, then you got to make sure that you're abiding by those provisions. Now, what happens if the contractor doesn't advocate on your part, right? What happens if they don't do what they're supposed to do? Well, I argue they didn't comply with the provision and that entitles us to get paid, right? So the key is this is a provision that you can use downstream with your subs. Watch out for it if you've got it. Some practice pointers. A lot of these we talked about. Make sure that you're properly submitting your claims with all the required contractual documents. Okay, oftentimes it will require lien releases. It may require affidavits. It may require warranties, whatever is required for purposes of submitting a claim. You want to make sure that you're submitting that. Okay, preserve your ability to seek payment for the claim, even if it's denied. So watch out for waiver. Okay. On releases, a lot of times it will make you release stuff through a date certain. Make sure that you put little asterisks on there saying this does not include retainage. It doesn't include my change order, 1 through 3. It doesn't include this, that, or the other. Put all that on there in writing because at least it shows that you're trying to preserve those claims. Okay. Price acceleration provision. You guys have heard me talk about this ad nauseum. Here it is again. Okay, you got to have this in your contract. I don't care if you're residential. I don't care if you're commercial, industrial. I don't care if you're roofing in space. It doesn't matter. You got to have this in there. The reason why you want this in there is because you cannot guarantee what prices are going to be. So what this does, it says, look, I'll cover up to 5% increase. I'll eat that myself. Anything over that, you got to cover it. Okay. This is also a great negotiation tool because a lot of times what I do is if let's say you've already got a signed contract, I'll go to the owner or the general contractor and I'll say, look, here's how we're going to resolve this current issue. But moving forward, let's come up with this provision and we'll agree to eat 15%. Anything over that, you got to cover it for us. Okay. Or whatever it might be. There are 3 parts to this. The first part is, you're entitled to payment if it goes over the certain percentage. The second is that you will provide backup. The third part is that last sentence, and rarely do I include that last sentence because it's hard to get your customer to sign off on it, unless it's a condo, because usually condos sign pretty much whatever you put in front of them. Not all the time, but a lot of times you're dealing with a condo lawyer, not a construction lawyer. So that last part says that if it goes up beyond a certain percentage, I put 10% in here that you can terminate for convenience. So good provision to have, but again, you might want to think about taking that out if you're just trying to get the first 2 in. Now, I want to talk about the most recent issue. Okay. This is brand new material for you guys who are the first to hear this out of my mouth. Starting July 26th, I believe was the first date, rolling through the end of August, manufacturers systematically put out notices. They were no longer honoring tier 1 special pricing on warranties and fuel surcharges. So if you negotiated special rates on warranties or discounts on warranties or fixed price on warranties, guess what? You no longer get it. Okay. Most manufacturers provided a grace period. They said, okay, here's what we're going to do. You got to the end of the year, you got till March, you got whenever it is. And that's great. Okay. Good for them. But certain manufacturers, there are certain very bad actors out there. I will not mention them by name. We all know who they are. Okay, that have said, yes, you get a grace period, but here's the problem with the grace period is you can't, they're saying you have to register the warranty and have it inspected. Well, in order to have it inspected for a warranty, what has to happen? You got to have the materials to complete the roof. And if you can't get the materials to complete the roof, then there's no point in that grace period, right? And I know that, and I caught it immediately, and you guys know that. So they're not really giving you much anything. So this is what it is. They're not really raising prices. If you're a tier 2 or tier 3 contractor, more than likely you're not going to see it. But if you had a special deal with them, then more than likely those special deals are gone. Okay. Now, I will say that, I don't ever believe in a final offer. There's just the next offer. So talk to your manufacturers. If you have a very good relationship with a manufacturer, I would reach out to them and say, I understand this is what you're telling everybody, but don't forget about me here. Let's work something out. How do you deal with this contractually, right? This is a contracts webinar. This is a warranty increase provision. Okay. And what I've done here is I've modified the price acceleration provision to specifically account for warranties. And what I've said is that the fixed price, dollar amount that you've got in your contract accounts for the warranty price as it is at the time of signing. But if for some reason it goes up beyond 5%, then the customer has to pay for it. And this is important to have in there because some of you may have had flat rates for warranties that are now, you add a 0 or 2 on the end for the cost that you've got to pay for an NDL or a 10 or 20. So this is something that's really critical. I just developed this as soon as I got the last round of notices, which were August 25th and 26th. I put pen to paper and tried to get this out. So this is a good one. Risk of loss. Risk of loss is a important provision because what it says is that you bear the risk of any damage to your work until the work is completed. And I gave an example here. This was a city contract. So how does this play out? Well, there are certain national general contractors out there that have an operating procedure where they say that you're in charge of all your work until the end of the project. You finish your roof, right? You demobilize, and this is a true example. Okay, I had a roofing contractor that had a 3-tier roof system put on. It was about $1 million project, okay? Put on the roof, demobilized the well-known general contractor, then proceeded to have other trades bring a scissor lift on top of the roof, okay? I'm not kidding you, a scissor lift. They, in addition to that, there was excessive foot traffic, all kinds of, penetrations and holes, and just, it looked like garbage. So naturally, the manufacturer said, the whole thing held water. The manufacturer said, we're not honoring the warranty. And the general contractor tried to push this provision on my guy, to which I said, no, that's not going to work, because you tried the same thing in these 5 other projects. It's not going to work. There's no judge or arbitrator on the face of the planet that's going to say it's okay that you allowed a scissor lift on the roof, right? So watch out for this kind of stuff. It's the details that kill you. Nobody pays attention to legal. They pay attention to scope, and they pay attention to sales, right? What you need to pay attention to, though, is this legal, especially now that we're getting into difficult times, because it's stuff like this that on the back end will kill you, okay? Managing lead times. Well, what's the biggest issue right now? Skilled labor, always an issue, but getting materials. You got plenty of work, but you can't do it because you don't have materials, right? So how do you deal with this? Well, there's a variety of contractual provisions that you can include in your contract that can help you potentially negotiate. In the previous webinar that I did for you guys, we talked about how to negotiate it if you've got an existing contract. I won't belabor that point, but I will talk about substitution and a few other things that you can do. Material availability provision. This is basically saying that in the event that you are delayed because you can't get materials, that you're entitled to an extension of time. It is not more money, it is more time, okay? The reason I did that is because it is difficult to get both. I prefer the price acceleration to get money, and I prefer the material availability to get time, because what I'm trying to do is I'm trying not to be too stingy, right? I'm trying to narrowly tailor it, keep it as short and sweet as possible to maximize the chance that I can get it sneaking into a contract, okay? This is that provision, very important provision. Again, this should be in all your contracts moving forward. Delay provisions, okay? We've had a huge uptick in delays year over year. Delays, you've got to understand how to navigate that. Usually there is a delay clause in your contract. It will talk about what you can do and what you cannot do. Okay, no damages for delay provisions. What that says is you are not entitled to cost, but you can be entitled to an extension of time. So there are ways around that, right? I wouldn't have a job if I couldn't figure out a way around that and how to get unexecuted change orders paid and all that kind of good stuff. But you need to be aware of it, right? So seek time for every aspect of your project. If it is raining, you must seek time. If you are delayed 4 hours because the HVAC contractor didn't do what they're supposed to do, you must submit a request for more time. Time is the only thing that really matters now, okay? Price matters, but you can account for that if you've got these provisions in there. Time that is very difficult to account for because you just don't know when you're going to get stuff, okay? One of the things that I've been most successful at, and we've had to really get into the details with delay claims, is that prior delays in a project can be used to justify current delay. What I've said before is look, just because if we could have mobilized 2 months ago or 5 months ago before this event started, we could have been complete before the material crisis really hit, right? But for your inability to finish the deck, we wouldn't be where we are right now, okay? It's a good argument. And a lot of times that's all I'm looking for, is I'm just looking for something to hang my hat on so I can negotiate out of the problem. Substitution of materials. We're going to talk about that. I think I've got a provision here. This is a standard delay provision to a subcontractor. So this is something that you would put in your agreement downstream to a sub, but this may be something that you receive from a general contractor, and they're nasty, nasty, nasty delay provisions, right? So you got the same kind of pass-through thing. Basically says, look, you've got to submit a delay claim within 5 days of the claim that caused the event. Okay, so at the start of the event, not at the end of the event. That's very difficult because a lot of times you don't know you're being delayed until you get far enough into it. Okay. The other part of it is that you've got to submit this claim in the same exact way that the contractor does. So you got to get it into them. They've got to argue on their behalf. If they get anything, then you get paid. If they don't, you don't get paid. Okay. So if I have the ability to edit this, I love to edit it. If not, then you need to be aware of what the timetables are so that you can get these delay type provisions submitted. Again, there's a way around most contract clauses, so I can figure out ways around this, but it's much better to paper the file, and at least you're in the game that way. How to deal with liquidated damages. Liquidated damages provisions are primarily found in the owner and prime contract. Okay, and what they say is for every day that you are late, you owe the customer $250 a day. Okay, past whatever the substantial completion date is, or issuance of the certificate of occupancy, or whatever it might be. Okay, so remember, if you get a liquidated damages claim, really the only thing that you're trying to do is beat back that claim. Okay, and to beat that back, you need more time. So I talked about obtaining time extensions. When you're looking to edit a liquidated damages clause, one of the things I really like to do is try to move your start date out, try to give yourself more time, try to reduce the dollar amount per day, try to allow for more types of delay. Okay, recognize that there are things like excusable delay, concurrent delay, the delay that's caused by others that can be used to justify the fact that you aren't really late, it's somebody else's fault. Okay, if you are faced with a situation where materials are not getting to you in time, then one of the things that you can do is attempt to rework your schedule to either accommodate other trades or to accommodate other portions of the work, so that you're maximizing efficiency without having to accelerate your own workforce. Okay, some products you can't do that, right? If you're doing a single family residence, it's just you, it's only you, that's all there is, right? But if you're doing a multi-tier roof system, new construction, I guarantee you there's somebody else that can get out there and do something, and hopefully you'll shave off, instead of a 6-month delay, you're looking at 2 months. Okay. Let's talk a little bit about general contract provisions. I do want to mention substitution provisions briefly. At the end of delay provisions, I mentioned substitution materials. You want to make sure that you've got a provision in your contract, and I included it within the last webinar that we did, where you talk about the ability to substitute not just materials, but systems. Okay, being able to substitute things like adhesives or caulk or whatever you've got, so that you can get the project done, is incredibly important. But word to the wise, make sure that you get approval to do that, not only from the upstream players, but the architects, the design professionals, but also the key manufacturers. Because one of the things that we've seen more and more as this crisis has continued to unfold is that manufacturers love apples to apples, they hate apples to oranges. So if you've got manufacturer A that's underlayment, but you've got an adhesive that is manufacturer B, sometimes they will use that as an excuse to not honor existing warranties. So get all the required approvals, but that can be a way to potentially help mitigate these concerns. Want to switch and talk a little bit about general construction contract provisions. A lot of times I get asked, Trent, I work for general contractors, right? And they just tell me, here's a contract, and I know I don't have a lot of room to negotiate. So what's the point? I'm going to sign it, and it is what it is. Well, yes and no. There's always room to negotiate. There's always things that you can do, even if they say you can't do it, right? There are techniques and tactics that can be used that are the equivalent of trickery, which, this is not a negotiation, it's war when it comes to dealing with general contractors. So remember, when you are revising something, you have to understand the psychology of negotiating, right? Less is more. So when I am trying to revise a contract, what I like to do is only redline a few words here or there. If I take big X's and stroke out entire pages, then not only does that stand a chance of not getting approved, but it also sends a psychological message that this guy's an a-hole, right? And, I'm speaking plainly, but that's what the mindset is who does this guy think he is? He's striking through all this great stuff I put in my contract, and more than likely the people that had some input on the drafting of the contract are reviewing the contract, right? So there's some ego there. You got to be careful about it. What I like to do is just make those few changes, initial it, send it back. The key thing is that when you're negotiating, make sure that everybody's on the same page. So if you send it back and you don't hear anything otherwise, follow up with an email and just say, hey, I just sent you the markups back. Just let me know you're good with that, and I'll go ahead and get started tomorrow. And if they send an email back and they say, yeah, I'm good, that's good enough, right? It's not great. It'd be much better to have the initials countersigned and everything in triplicate, but this is construction, right? So the key thing is you want to have something that evidences that both the parties understand what the terms of the contract are. When I'm negotiating or reviewing contracts, I'm only focusing on the biggest ticket items: payment, insurance, identification, disclaimers, the key things that I think are going to either prevent you from getting paid or get you in trouble. I'm not going to sit there and revise the cleanup provision or the safety provision or stuff that's just boilerplate junk that nobody necessarily cares about. I'm only focused on those critical key things, right? Because that's all that really counts. Now, I've got 6 or 7 advanced level expert techniques that I can do another webinar at some point, but I want to give you one of them. Okay. So for those of you that are listening to me and say, Trent, I love your provisions. This is brilliant stuff, but I can't get any of this in my contract because GCs say I can't edit anything. Fine. Well, let me give you another handy tip. Okay. Even if a general contractor says you cannot edit my contract, inevitably you have to provide a scope of work, right? You've got to provide some means and methods or something that indicates what you were doing. So even if they spoon feed it to you and say, we want you to do this, that, and the other, you still got to provide something. Oftentimes that scope is included as an exhibit. What I like to do on there is I like to put, either I add terms and conditions in that exhibit. So I like to be sneaky about it. And I like to say, this contract does not include, any change of the existing drainage. We'll provide, XYZ system, tapered package, and here's a waiver of consequential damages, right? You have 3 or 4 scope related issues and then you throw in a legal, right? To see if how much they're really paying attention to it, because it may just be an estimator or something like that that's looking at it, not somebody that's got a legal mind or somebody from management, right? So the other thing that I like to do is I like to put just a plain boilerplate scope in there and say that for purposes of this contract, we are incorporating by reference our standard terms and conditions, okay, which can be found at this link, or which can be provided upon request. Okay, anything like that, is that great? It's not great, but it's good, okay? And what that means, provided that you do have a standard terms and conditions that can be located and identified at that time, you can have a lot of really good stuff in there that can potentially help you and give you an argument to get off center on some of these worst things. So what I'm trying to point out to you here is it ain't over till it's over, right? Just because somebody tells me I can't do something doesn't mean I can't do it. I just got to be smarter about how I go about doing it. Again, be another great webinar. I'd love to talk about it. So let me give you an expert level change order tip while we're here, okay? Unexecuted change orders. If I asked the audience, how many of you have ever had problems getting an owner or a customer to pay for extras? Everybody would raise their hands, right? And I could see a lot of you smiling right now. So yeah, how do you do this? So what I like to do is, here's an example. Owner sends you an email and says, I need you to do these 3 wall panels on this roof that wasn't originally identified in the plans and specs. And yeah, don't worry about it. We'll pay you for it. So they tell you that. It's always oral. That's how they tell you, right? They tell you over the phone or at a job site meeting, whatever, right? So you follow up with an email because you listened to me and you said, you know what, I got to pay for the file. So you follow up with an email and you say, it is my understanding, Mr. Owner, that you want us to come out this Friday and do the work on these other 3 wall panels, and that it is extra work that's not included in the original plans and specs, and that we'll be compensated for this. As a result, here's our change order, okay? Then what happens is if you don't hear anything, which inevitably is the case, they don't respond, they don't do anything, Then I like to respond and I like to say, you know, this is to confirm we are mobilizing. This is Thursday. We're mobilizing tomorrow morning. It is our understanding that you want us to do this extra work, that you've identified it as extra work, and you've agreed that we're going to be paid for it. If any of the above is incorrect, please notify me before end of business today. Okay, otherwise we will proceed with doing the work tomorrow. What that does is a couple of things. One is it writes down on paper what your current thoughts are, right? So you got that electronic understanding of where your mental impression is. The second thing is that there are 3 types of responses that you can get. One is, yes, that is correct, we will pay you, which is great, you got it in writing, okay? There's 2, we're not gonna pay you pound sand, get out there and do it. In which case, at least you know what to do. You can make a business decision, do I wanna do this or not do it, and face the consequences. Or the third is they don't respond at all. Now, if they don't respond at all, there's an argument known as promissory estoppel. I won't bore you with legal stuff, but the idea behind that is that you detrimentally relied on their promise to pay you for this additional work. So you might be able to use that email trail to evidence that these guys aren't acting in good faith and therefore you're entitled to additional compensation for it. So don't just sit idly by and take it. You know, use these techniques and tactics. Again, I got dozens of them, but these are just a couple of examples and I wanted to get those to you. Contingent payment, pay if paid clauses, okay? Pay if paid clauses are dangerous, okay? What they say is, I, the contractor, don't have to pay you, the sub, until I'm paid by the owner, okay? But in Washington, there are specific requirements in order for it to be valid. You've got to have magic language. And I highlighted some of the language here. You know, it's a condition precedent to payment, okay? You got to have, or it's conditioned upon. So you got to have that special magic language in order for it to be valid, okay? What I like to do, remember what I just talked to you about, if I had my little red pen out and I just struck those words right there, and I just said, look, you know, pay within a reasonable time, guess what happens? I just gutted that whole provision, right? So use legal as a weapon. This is a great time to do it, right? I don't like these provisions. These are one of the ones that these are in my top 5 provisions that I look to edit because you are not a bank. You are doing work and you should be paid for it. If the contractor wants to gamble his or her money, then God bless them, but you are not. So do not be a bank. Do not sign a contract with a contingent payment clause in it unless you really know what you're doing. Now, there are ways around it. How do you beat it? Well, if it lacks the magic language, a couple of cases right on point in Washington that says that. So if it doesn't say it's a condition precedent, if you're dealing with an out-of-state contractor that doesn't understand the law, all those types of things you need to watch out for, okay? Contingent payment is not valid in every single state. Many states bar it. So if you're going, across the border, they recognize that it may be different, okay? What I like to do is, if it incorporates a prime contract, okay? So if the prime contract says the subs will be paid within 14 days of receipt of payment, by the contractor. Well, there's an issue there because you got conflicting provisions. You've got the subcontract, which says it's contingent payment. You got the prime contract, which says it's not. So who's on first? Okay, oftentimes you got to interpret the contract to figure out, does the sub trump the prime? I don't know. That's a good argument, okay? And here's another trick. A lot of this is trickery, right? So, course of conduct between the parties. How do I beat a contingent payment clause? This is how. I go to the contractor and I say, hey, I know you haven't been paid by the owner. I get it. Whatever, I've got this supplier out there that I owe $25,000 to. He's going to record a lien and then it's going to be bad for all of us. Can you just do a joint check to me and them and just get them out of here so that we don't have to worry about that? Oh, yeah. Well, that makes sense. That I can come out of pocket for, So they struck a check for that. Well, guess what they just did? They just used their own course of conduct to negate what that provision said, okay? So then I can turn around and say, okay, well, you broke it once. So why did you break it once? We should be entitled to reasonable payment, payment within a reasonable time. Let's go that way, okay? There are always ways to attack, always ways to attack. You just have to keep going. You always got to keep going. So when you face one roadblock, you look for a different path. Identification. Identification is one of the most painful things that we have to deal with on a daily basis. And one of the big things that I want to mention to you is the fact that if you deal with an indemnification provision, and I'll give an example here, to the fullest extent permitted by law, a contractor shall indemnify and hold harmless the owner, architects, consultants, and agents. So on and so forth. A couple of things that you want to watch out for here, and I want to talk about insurance as it relates to that, is when you get an indemnification provision, the first thing that you need to do is watch out for legalese. Okay, what I like to do is I like to use capitalized terms that I defined previously, and I like to use legalese so that nobody has any idea what I'm talking about, right? And I do that intentionally so I can get what I want. So when you see terms like indemnity, indemnitor, all that kind of stuff, you need to make sure that you understand exactly what you're doing. Every indemnification provision that you receive should be limited in scope, right? It should be limited to only your bad acts or omissions. You should never, ever agree to indemnify anybody in whole or in part for anything other than that, right? That's just it. It's only your bad acts or omissions. If you screw something up, then yeah, brother, I'm going to hold you harmless for that. That's what makes sense. And the reason that's important is because of insurance. Okay, nobody cares about indemnification until you get that claim, because once you get that claim, there's a lot of issues there. You got to deal with CGL policy problems. You've got the interplay with additional insured status. So many of you will see additional insured and be asked to, name the architect as additional insured, the owner's rep, it goes on and on and on. And it doesn't cost you that much out of pocket, right? At the beginning. The problem is that anybody that you gave additional insured status to, they stand in your shoes. So they can make a claim directly to your insurance company. They can seek their attorney's fees directly from your insurance company. It is a killer. So what I like to do is I like to limit it to, again, only your bad acts or omissions. Additional insured status is limited to only to the extent that you have done something wrong. Avoid references to ISO. If they start mentioning ISO, which are standard insurance forms for additional insured status, they're usually bad for you, okay? So watch out, pay attention to AI. It is a silent killer. So identification, what are we gonna do? We're gonna keep it limited to only your bad acts or omissions. Don't ever agree to do it. If it says in part, strike that in part, okay? Only your bad acts or omissions. Insurance, again, AI, watch out for anything that expands beyond your bad acts or omissions. Keep it to you only. Let's talk a little bit about roofing specific clauses. There are tons and tons and tons of them. But what I want to do is I want to go through some of the ones that I thought would be most beneficial for you. Okay. So these are the ones that we're going to talk about. Driveway, some of these deal with residential, some of these are commercial, some are both. Driveway disclaimer, the oil canning disclaimer, the color match disclaimer, the acceptance of deck, and the interior damage protection provision. Okay. These are the ones that I rely on the most when I'm litigating claims. So you have to understand your contract, the contract is a lot like a living, breathing document. It is something that you constantly change and evolve as you face problems. So as you encounter any problem with a customer, you should go back to your contract and make sure that your contract addresses that. If it doesn't, then you should address it, right? Because if it happens again, shame on you for not having something that deals with it. Now, if your guys just screwed something up, it is what it is, right? There's no contract provision for that. What you can do is you can make sure that you've got certain provisions that account for things that you see over and over and over again. I often get asked, especially for residential contractors, I don't want to scare away the customer. I'm afraid I'm going to scare away the customer, right? And I get that. I hear that. But with a residential contract, what I like to do is, have the terms and conditions on the proposal on the front, which talks about what you're doing, terms and conditions on the back, in smaller font. It doesn't have to be large. I can't put what I would normally put in a paragraph in a sentence, but I get something in there. And 9 times out of 10, people are driven by price. They're not driven by the, driveway disclaimer. That's not going to necessarily prevent them from going to. If it does, everything is negotiable. You know, I'd rather have it in there and protect myself than not have it in there. Okay. So let's talk about some of these provisions. The driveway disclaimer. This basically says that look, you're going to be responsible for these things. You recognize that, you know, curbs, walkways, driveway structures, whatever it might be, that all of these are potential problems on a job site. So I have a very specific one that focuses just on driveways. Okay. And what it says is that the price includes the fact that your suppliers are going to rooftop materials using heavy equipment. If they want to avoid that, if they are concerned about the potential for driveway cracks, you can give them a hand load price, but it's going to be significantly more. Okay. And again, people are price driven. So 9 times out of 10, they're going to pick that other option. The other thing that you have to watch out for is the undisclosed utility lines that's on the back of a deck. You know, every month I've got somebody that hits a pipe that's on the back of a deck and it floods out, you know, the house. That stuff shouldn't be there. It's against code. We all know that, but it's great to have that in a provision. Again, it's hard in a residential contract to put everything that you normally would have in a commercial, but you want to focus on those key things. This is more of just a catch-all type provision. Let's talk about oil canning. For those of you that do metal roofing, you know what oil canning is. What is oil canning? Well, if you ever ate like, you know, Campbell's soup comes in oil in a can, it's got those ridges on it on either end. That's what oil canning looks like. Okay, it's primarily an aesthetic issue. It usually is in lighter gauge metal over longer spans. And if you've been doing metal roofing long enough, you can generally know based on the scope when you're going to face an oil canning problem. Not all the time, but you can usually kind of tell, okay, you might have one in these certain sections. Although there are sometimes you just don't know until you get up there and you place the panels on. So what I like to do is I like to account for it. And I like to say, look, we're going to do our best to not do this, but it's an aesthetic issue. Doesn't necessarily affect, you know, the performance of the system. Customer, you understand this. This is what it is. Okay. Does that mean that you're not going to go in there and try to repair it or make it look better? No, of course you can do that, but you need something that's going to be able to protect you in the event that you've got, you know, a metal roofing problem involving oil canning. Nobody likes it. Right? From an appearance standpoint, it doesn't look good. It's just a problem. It causes a lot of issues and it's expensive, right? Because what it requires is you taking that off, going back and trying to fix it. Sometimes it can't be fixed. You know, no matter how many times you go up there and try to fix it, it ends up, you know, looking bad. So just recognize that it's an issue, and that's why I like to have that in there. Color match disclaimer. Okay, this is pretty much applicable to any contractor out there. If you're in a position where you've got to match colors, it's very difficult to do, especially when materials are exposed to UV. So it doesn't matter whether it's shingle, it's tile, it's, you know, even repairs to a TPO roof, right? You know, sometimes patches don't necessarily match 100%. Now that a lot of TPO roof owners care, but the issue is what you need to be able to say is, look, you'll do your best to match, but this isn't a guarantee. So they need to understand that, you know, the elements are the elements. If they want a perfect match, they can get a re-roof. And that's what you need to tell them. This most often comes up with shingle and tile replacement is where I see it. I'm going to spend a little bit of time talking about acceptance of deck. Okay. We all know about problems with lightweight concrete and moisture absorption. I'm not going to bore you with that because we've heard about it over and over and over again. But there are a lot of different issues that you can face with decking. Okay. Not just lightweight concrete. And the issues, they consist of everything from moisture content to structural sufficiency, to undulations, you know, ponding water. You see it all the time. You know, you put on that roof, and then all of a sudden you got ponding water, and you know it's like whack-a-mole. You fix one, and then you get another one, and you fix another. It's very difficult to figure all that stuff out, especially on low slope systems. So what I like to do is I like to say, look, my responsibility is deck up. You know, I am only investigating the surface of the deck. I'm not doing, you know, advanced, you know, testing of this deck to determine moisture content, structural capability. That's not my job. If you want it done, go hire somebody, leave me alone. Okay. And I like to have that in there because a lot of times you will have failures. You'll have bubbling, you'll have, failure to adhere, the adhesion type problems as a result of moisture. You'll have, water intrusion, you'll have leaks, you'll have condensation, you'll have a whole host of just nightmarish things. And sometimes it's difficult to pin it on a certain thing. You've got everybody pointing fingers at each other. But having a provision like this in your contract gives you more teeth because you can say, look, I took the deck for what it was. Our guys inspected it. Here are the photos. The deck looked fine. It was dry at the time we put the stuff down. If it's not sticking, it's a problem. Okay. So obviously there are things that you can do from a scope standpoint to make sure that there's better adherence. I'm talking more about legal. This gives you something to kind of hang your hat on. One of the things I want to talk to you about is interior damage protection. And a lot of people, the contract is, it helps you prosecute claims and helps you defend stuff, right? That's really the point of a contract. But, what it also does is it helps educate. A lot of times you're using your contract to educate your customer because they may have a certain idea of what is right or wrong in their head. It doesn't match the reality of construction or what's in your contract. So what I like to do is I like to manage their expectations, and I like to say, look, you got to understand that we're re-roofing, right? That there's going to be disturbances. I got, 10 guys on a roof and they're shaking stuff around, they're nailing stuff, they're banging stuff. I don't know what's going to happen, right? So I need you to do your best to protect your interior, stuff. Take stuff off the wall, make sure you bubble wrap that Ming vase, whatever you got, right? I've had a lot of commercial claims from big box stores where insulation has fallen on somebody, or stuff like that. You can't account for everything that's going to happen in the interior of the space while you're doing your roofing work. So what you need to do is you need to make sure that you're notifying your customer of the potential, which they should know already. But by having a contract provision in there, what it does is it gives you the potential to say, look, I'm not responsible for this. This is all on you. Submit it to your carrier. You got to deal with this. Okay. Again, I think this is more about educating. It does help when I get these kinds of claims. It's one of the first things I point to and say, look, we warned you, we told you about this. What did you do to protect this? You're responsible for it. So what do you want from us? And a lot of times what it does is backs people off. What I'm trying to do in disputes a lot of times is I don't want to take stuff to the Supreme Court. That's not going to help you and it's not going to help me, right? The goal is to resolve things as quickly as possible and move on so that you can get back to roofing. Sometimes you can't do that. Sometimes you got to go to war. I love war. I get it. But at the end of the day, a lot of these contract provisions help do that because they take your customer off that mindset and they realize that, hey, I might have some exposure here. I might have to take another look at things and figure out, is there a better way to do something? Okay. So one other thing I want to mention to you, this is just another, I threw in an extra acceptance of debt provision. As you're dealing with both interior protection and acceptance of debt, you want to make sure that you're doing everything that you can to inspect ahead of time, right? As you're inspecting things, one of the things that I like to do is make sure that you've got both video and photographic evidence of existing conditions prior to the start of work, during construction, and if you demobilize. There's nothing more important than getting the existing condition of that roof after you've walked off, right? Because a lot of times when you have completed a job is when stuff goes bad, right? You get people walking on the roof. My example of the guy that brought a scissor lift up there, you want to know exactly what the roof looked like on the date it was completed. So photographic evidence is great if it's good for you. If there's issues, try to avoid those photos or send them to your lawyer so they become attorney-client privilege or attorney-work product. Let's talk about warranties. And I mentioned to you a little bit about warranties before, okay, as it relates to the increase in prices. Here are some things that you need to think about. Many of you may offer workmanship warranties. Okay, most of you have a workmanship warranty. Okay, 1-year workmanship warranty, 5-year workmanship warranty, 10-year workmanship, whatever it is. But rarely do you have a separate document entitled warranties. Okay, you don't go through the ins and outs of what is important and what is excluded. So it is not an unlimited warranty. There are exclusions. So let's talk about them. Okay, you want to exclude damage by wildlife. Okay, I can't tell you how many claims I've got because of birds, or squirrels, or what else, bats. These things like to chew on adhesives and coatings and all kinds of stuff. Woodpeckers. I had a claim not too long ago, a woodpecker tearing up the flashing on a chimney. So it'd be nice to have that you're not liable for that, right? One of the things that you want to definitely do is limit testing to manufacturer specs. Now, sometimes you can't do this if you're on FM jobs, but the worst is then they say, okay, well, we need to bubble test this. Okay, I can rig a bubble test pretty quick. I don't necessarily trust them too much. So any of that wind uplift testing, advanced testing, infrared, nuclear, you name it, limit it to whatever the manufacturer says. Okay, if it's in the manufacturer specs and they say it's required, you're going to do it. Otherwise, you're not going to do it, or they're going to have to pay you more to do it. Okay, it is always in your best interest to do whatever testing. If testing is going to be done, you do it, not somebody else. Okay, I'll say that again because I want to hit this point home. If the owner or the general contractor says that other testing might be done, even though you objected to it, you've done whatever you can to prevent it, you want to do it. Okay, because if someone else does it, especially without you present, guess what they're going to say? This is not a manufacturer problem. This is a workmanship problem. Okay, do your own testing to the extent that you can, because you can help control the environment. Okay, hopefully you guys understand what I mean by that. Limit the warranty to the designed performance value. So a great example is if you get excessive winds, you're not going to warrant anything past the design performance specs, right? Makes sense, but it'd be great to have that in writing. Talk about the intended use of the building. The warranty is provided based on the current intended use of the building. If for any reason the intended use of this building changes, this warranty will be void until such time as the contractor, reapproves it. And the reason that's important is that if originally you provided a roof system for a warehouse that is then subsequently converted into an apartment complex, then guess what? You probably had the wrong system on there, or you didn't properly take into account R values or whatever else might be needed, right? You might have a condensation problem. So you want to know about that so you can go out there and either say, yes, I will approve it, or no, I don't approve it, and I'm doing this in writing, so that if bad guy lawyer gets it, they can say, you know what, they warned you about it and you didn't do anything about it. Okay. Exclude maintenance and work done by others. If anybody goes up on that roof whatsoever, your warranty's void unless it's you. Okay. I don't want, cousin Larry out there, patching a hole. I don't want, the solar guy up there screwing stuff up. I don't want the HVAC guy up there. I don't want anybody on my roof. My roof is sacred ground. Don't you dare touch it, because if you do, your warranty is void. Okay. The other part of that is you can't touch it, but you got to call me out to do it, right? Which gives you another, service call that you can come out and charge for. But exclude that work, because I guarantee you it's going to be the DirecTV guy or somebody's going to do something to your roof and they're going to blame you for it. Okay. Limit design liability. This is something that I think is often overlooked by a lot of roofing contractors. You are providing a roof. Okay, you are not an architect, or at least I don't think you are. You're not an engineer. You are providing a roof. So the only thing that you are doing is installing a roof pursuant to either specs that were provided to you or pursuant to manufacturer specs. That's all you are doing. You are not creating your own specs. You are not doing anything from a design standpoint. Limit your design liability, okay? Because you don't want to get into a situation where they are saying that based on the current roof system, or the current structure, you did not provide the correct design for this roof. Okay, all you're doing is installing a roof. Some other things I want to mention about warranties is be very, very careful about what you say you are going to give someone. Turning to our residential contractors, if you say you're going to give them an NDL, you better make sure that you can get an NDL. Okay, if you say you're going to get a certain type of warranty from a certain manufacturer and you can't get it, then that gives the other side a basis to potentially not pay you. So be very careful about that. I'm working on some options right now because of this recent warranty issue to potentially get around this altogether. So stay tuned, okay? But as it stands right now, watch out for what you say. Make sure that you can deliver it, because it's hard to convince a third party that they should do something if it's not spec right, okay? So what I want to do now is, marketing people would kill us. We've got a shopcotney.com. I'm giving every Roofing Contractor Association of Washington member a discount 10%. We got estimating training on there, contracts, whatever you want. I'm sure my marketing people are smiling somewhere. But what I want to do now is answer any questions that you guys might have. I covered a lot of different stuff about contracts. We went over the materials issue. We went over roofing specific stuff. I went over some general construction contracts provisions. But what questions can I answer for you? Again, I can talk about anything and everything that is contract related. So if there's a specific issue that you're facing, or if there is something that you would like me to talk about, hit me up in the chat or the Q&A, and I will be happy to do it. So I'm not hearing anything. So what I would say is, stay tuned. Contract provisions are constantly changing. I'm always trying to come out with something that addresses what the current issues are. In addition to the materials issue, the big news that came out last week was Biden's mandate on employers over 100, right? So even though it's technically not a contract, your employee manual is basically a contract. For those of you that are non-union, there are provisions and things like that you need in there from a vaccination standpoint to cover that. So looks like we do have one. Oh yeah, actually that was the question. Dan asked, how do we handle new vaccination requirements when not part of the contract but now being requested? So this is a great question. Dan is asking, what if your customer says that your crew has to be vaccinated, which I got to tell you, I'm seeing almost every big box store require it now. Federal government requires it. You're seeing it over and over and over again. So one of the things that I would really recommend is that you put in your contract moving forward that if you've got to do it, your subs have to do it as well, okay? The key thing is that if you are already in an existing contract, okay, and they say you must have a vaccinated crew, understand that you already have an existing contract and that you are not required to do that unless it's federal work, in which case you have an alternative right now, which is testing, although there was some suggestion last week that is being done away with. So what I would do is go back to the customer if you have an executed contract and say, look, this is not part of our contract. You can't mandate this. There's no basis for you to mandate that. There is no rule that applies to us that requires us to do that. We can talk about additional consideration for it, but I don't have to do that, okay? What I would recommend is if you are not mandating that your employees be vaccinated, at least have one crew and some alternatives that can be vaccinated so that can assist you. Make sure that any subcontract that you have puts that onus on them as well, saying that if I have to be vaccinated, then you have to be vaccinated, okay? Definitely something that I think is worth putting in your contracts. And I can tell you that you're only going to see more and more of it. It's going to become, I seriously doubt that the attempt to do an emergency temporary standard in OSHA on this is going to pass without a lot of legal challenge. In fact, I know it's going to be challenged, but there's still a lot that Biden can do from an executive order standpoint. So getting this stuff into your contracts now is going to be beneficial. So any other questions I can answer for you guys? And again, recognize you got a member benefit, right? If you're a member of the association, reach out to us, call our customer service, say you're a member. It routes to me or routes to whoever the right person is in our organization, and we can help answer for you. So I appreciate you guys as always. And Tracy, I'll turn it back over to you.
Thank you so much, Trent. I really appreciate it. That was excellent information. Anybody who wants a copy of this, we will have this recorded and up on our YouTube channel in the next couple days. But if you want a copy of PowerPoint or anything like that, we can get that for you. Just send me a quick email and I will forward that on to Trent's team and they can get that out to you. I also want to remind you that our biannual is coming up on October 21st, and Reed Ripple from the NRCA is going to be here with us. So grab some more information on that on our website, and look for our weekly newsletter as well. And Trent's going to be busy in the next week. You're going to be at what? Best of Success, WRE, and the NRCA Town Hall phone call on the 22nd. So we are really super lucky to have you take your time out of your busy life to join us and spend some time with us. And like Trent was saying, if you're an RCAW member, you do get a discount with Cotney, and we would love you to utilize that discount and ask any other questions that you may or may not have from today or otherwise. So with that said, thank you everybody for attending, and thank you again, Trent. We really appreciate you.
Thanks, guys. See you next time.
Bye.